a case-by-case analysis on, how to work with the employer on potentially a waiver of the non-compete or a buyout of the non-compete or other negotiations. My name's Arden Miller, and I'm in the corporate department of Cohen, Pollock, Merlin, and Turner, and my practice focuses on assisting healthcare and dental professionals and practices with their corporate and employment needs. So any given day, I might be helping an orthopedic surgery practice update their shareholders agreement, or I might help them when a senior shareholder is retiring and withdrawing from the practice. I might be helping as they prepare to sell to another practice or private equity. On the other hand, I also help many individual dentists, oral surgeons, orthodontists, all types of physicians enter into employment agreements, enter into partnership agreements, and then on the flip side, I often help them navigate departure from a position, and that can sometimes entail negotiating, a buyout of a partnership and even a buyout of a restrictive covenant in some way. So I really focus on assisting professionals and business practices in their everyday corporate employment matters, and that can entail a wide range of transactions. A common question that I hear from clients most often is whether or not their non-compete clause is enforceable. And the answer really depends on many factors. If you're in Georgia, it depends on the scope of the restricted activity, the duration of the restricted covenant, and the radius, so the geographic area. We'll look at all of those factors, but in Georgia, most non-compete clauses are enforceable, and courts even have the right to do what's called blue penciling. So if a restrictive covenant in dispute went to court, a judge could actually come in and use a blue pencil or pen and take out the unreasonable part of the restrictive covenant to make it reasonable. But that's something that many physicians and dentists are interested in understanding more about, because when they want to leave a position, sometimes they feel as though they have to move homes, they have to relocate their entire family, and so they want to know whether or not the restrictive covenant is in fact enforceable. And then as a follow-up to that question, if it is in fact enforceable, they want to understand ways that they can possibly get out of the restrictive covenant or limit it in some ways. And that's a case-by-case analysis on, how to work with the employer on potentially a waiver of the non-compete or a buyout of the non-compete or other negotiations regarding the restrictive covenant, but that's a very hot topic. The reason that many healthcare clients are interested in understanding whether or not their non-compete clause is enforceable is because the FTC enacted a ban on non-competes under the Biden administration. There was a proposed ban on restrictive covenants in an employment context, and that was overturned by the courts. That is no longer applicable, but it was in the news constantly, and many physicians, dentists, oral surgeons, orthodontists were excited about this ban because they felt like they would be able to freely go between positions without needing to relocate them and their families. That FTC ban is pretty much a tabled issue for now, and I don't foresee any changes to the current laws. It's going to be a state-by-state decision. The states will decide how they're handling restrictive covenants in an employment context. And if you're in Georgia, we are a pro-employer type state for restrictive covenants. We have a Restrictive Covenant Act of 2011, and our laws tend to favor the employers in terms of enforceability of the non-compete. Someone that would want to call a healthcare-based attorney could be someone coming out of training and getting ready to sign their first employment agreement ever, they need to know so many different things. What are the termination rights? Because some contracts say that both parties can terminate without cause, for example, with 90 days notice. Other agreements might say the employer can terminate at any time with 30 days notice, but the employee, the physician in this case, cannot terminate for any reason in the first 3 years without significant monetary damages. That's something that we see all the time, and if the physician had not contacted an attorney, in this case I would be reviewing it and helping them understand it, they wouldn't know to go back to the employer and say, wait, this termination clause should be reciprocal. If you can terminate me with 90 days notice without cause, then I want to have that same right. Another type of healthcare professional that would want to call an attorney is someone that's getting ready to buy into a practice in private practice, because they're going to be investing a significant amount of funds in most cases, and they are often signing a new restrictive covenant in this case that can be up to 5 years in Georgia if they ever leave the practice and sell their interest. So they need to understand, if they become a partner, what does that look like in terms of profit sharing? How is the valuation of your interest calculated for the buy-in? And what happens if 2 or 3 senior shareholders retire within the first few years of you becoming a partner? Or what happens if things change and you want to leave? Where can you go work next if you want to leave earlier in your career? And what will you be paid for your interest if you leave, and under what circumstances? So those are situations in which people call me all the time. Another type of physician or healthcare professional that might want to contact me would be someone that's dissatisfied with their current position because of certain potential breaches of their existing contract. So, for example, I've recently had a client that we negotiated during the employment agreement phase to stipulate her call coverage would not exceed a certain threshold. Well, the practice has lost certain physicians, others are on maternity leave, and the employer has, approached the physician and said, well, you need to step it up and take additional call, and that's not, acceptable for our client, and so we have the contract to back it up. She does not have to take additional call above a certain threshold, and if she chooses to do so with her consent, she will be paid additional compensation for that call. If you don't negotiate something like that or understand what your contract says, you could be in a position where the contract says all physicians take call proportionally, and if that means that there are less physicians, that means you might be working more weekends and holidays. Other situations might be when a person feels as though they're working in excess of what their clinical or admin hours were expected to be during the contract negotiations and based on the contract. And sometimes that just takes the lawyers working it out and trying to figure out a happy medium. Sometimes it's just me advising the client on how to approach it and helping ghostwrite an email or letter to either the hospital or the private practice CEO. There are many different circumstances in which a healthcare professional would need an attorney. So I would advise clients that are interested in understanding whether or not they should just accept the employment agreement that they're given and believe that everything will be okay, rather than take their time, ask for an extension and a deadline, work with an attorney, not impulsively sign something. I would tell them that they have spent so many hours, weeks, months, years training to be a physician or a dentist, and it's worth investing in their ability to make a living and live in a particular city or area in which they choose to live. It's really important to take the time and invest in your future by having a lawyer review your agreements to make sure that you're entering into an employment or partnership situation that's beneficial for you, and that if something happens and it doesn't work out, it's an arrangement that you can walk away from and still be able to work in the specialty in the area that you want to.